be
Identified facially.
identified facially. What are your full names?
It is Annette Vergeer, my lord.
How do you spell Vergeer?
Vergeer.
Yes.
Do you have any objection in taking the described out?
No, my lord.
You swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth. Please raise your right hand and say, so help me God.
So help me God.
Witness is sworn in, my lord.
You can either stand. Are there any chairs that are clean? It's up to you.
Thank you, my lord.
Ms. Nell?
My lord, the witness has pictured copies and original. I beg leave that one of the reports be handed into the court so long the witness will testify from the contents of that.
Yes, you may do.
State also has a copy.
May do, sir.
I take it to be exhibit 5x T, my lord.
That's correct.
I've got an original signed copy for my lord, if that's...
Yes, I can have that.
My lord, Ms. Vergeer, first of all, your qualifications, your background, your employment, etc. All of that and
I've done BA Social Work Honours at the University of Pretoria during 1980. Field of interest, pre-sentence and psychosocial reports. I am employed at the Department of Social Development based in Krugersdorp. I've got 34 years of experience. I have compiled a report concerning the accused before the Honourable Court.
Is that now accused number one?
That is accused number 1, Mr. Zak Valentine.
may you then proceed in reading the contents into the report.
I will start on page 4, my lord. On instruction from a state advocate for the accused at state expense, a request was made for a psychosocial pre-sentence report in respect of Mr. Zak Valentine, hereinafter referred to as the accused. The accused circumstances have been investigated and the following report can be submitted. This report was based on information obtained through different interviews with the accused in prison. The undersigned also had the opportunity to make use of the assistance of an APO, Assistant Probation Officer, to clarify information and to assist where applicable. Sources consulted with are attached. Opinion is based on information obtained during the time of the different interviews and subject to review following the availability of new information that might not have been available during the time of the initial interviews. For purpose of this report, little information could be obtained in an attempt to assist the court. Most of the information confirmed have already been placed before the court. The undersigned went to see the accused on 2 different occasions in prison. Identification details: Zak Valentine, born the 3rd of August 1985, 34 years old. Relationship aspects: marriage relationship. According to the accused, he and his now deceased wife were married during 2010. They were married for a period of almost 2 years. The couple did not have any children. The wife of the accused was subsequently murdered. The accused was charged and convicted of her murder. The accused denies all involvement. Parents of the accused. According to the parents of the accused, the couple only knew one another for a period of 5 months before they were married. The couple has no children together. Stated that his deceased wife had a close relationship with Cecilia, accused too, and that he had to fetch her every evening after work from accused to's place of residence. They would spend more time at the residence of accused two than at their own place. The parents of the accused stated that he became more distant after he also became friends with accused two and that they did not understand his behavior. It is alleged that the co-accused alienated him from his family. He is currently not in a serious relationship. Background circumstances: the accused was born in Carltonville, where he was raised and mainly grew up in Western area as a young child. The parents of the accused still reside in Western area. The mother of the accused is employed as a principal at a creche. The father of the accused is a retired architect. The accused was born one in a family of 2 children. The accused is the oldest sibling. His younger brother works at a company in Rustenburg. No problems have been confirmed concerning his upbringing childhood years. His childhood years should also be evaluated from within his own unique framework and circumstances. According to the accused, he was exposed to a fairly happy and stable upbringing. His parents provided for them emotionally and financially. He has positive memories of his childhood years. The accused confirmed a strict upbringing, loving and supportive home, good and stable homely environment, religious home, Christian-based home. The parents of the accused confirmed the following information, confirmed the said information. According to them, the accused was brought up within a stable and overprotective environment. It is alleged that they provided a safe and secure environment for them, but that this might have been his biggest downfall, as he became easily influenced and misled. He was gullible. Despite everything that he has been accused of, they were willing to support the accused and to provide further and future stability. According to them, the accused was confirmed to be a more quiet and reserved type of a person. He was never a difficult child, can communicate, and used to have a few friends. They believe that after he became involved with the co-accused, that they were isolated to a certain degree and spent more hours at their place of residence than anywhere else. His parents stated that they were and still are shocked and in disbelief concerning his involvement in the crime. They will support him. He's very concerned about the possible outcome of the criminal case. They beg the court for mercy. School work report. The accused attended the following schools. He completed grade 7 at the Gerrit Maris Primary School. He proceeded to the Western Area High School. The accused was actively involved in various sports and excelled academically. He obtained a distinction in mathematics. The accused, after completing grade 12, was able to pursue with his studies at the University of Potchefstroom. He enrolled in an actuarial science course and obtained his degree, 4-year study course. According to the accused, he also obtained a distinction in mathematics at the University of Potchefstroom. The accused, after completing his degree, went to live abroad in London, period of 1 year. According to the accused, he managed to obtain a working position abroad whilst touring. The accused then returned to South Africa and accepted a working position at ABSA, financial advisor, period of almost 4 years. He then went to Discovery, financial advisor, period of 3 years. The accused was working at these companies, were earning an above average income, approximately 70,000 per month. According to the accused, he then started his own forex trading company, Entire Dietary Training. It is alleged that he only had this company for a period of approximately 2 months, when all of the inquiries and problems concerning the case started. Per the accused, he was told that the accused too had claimed on his policy and that he had to go into hiding. It is alleged that he started receiving SMSs from various people. It is alleged that he was afraid and did not want to be expose his family members after what had happened to his deceased wife. It is further alleged.
You must start the portion in brackets.
My Lord wants me to read the portion in brackets as
I
well.
think where you've got, because you're reading your record, you're reading your report into the record, but you must start what appears that accused 2 also wanted him to go into hiding.
Okay. Per the accused, he was told that accused 2 had claimed on his policy and that he had to go into hiding. It is alleged that he started receiving SMSs from various people. Accused 2 also warned him to go into hiding. It is alleged that he was afraid and did not want to expose his family members after what happened to his deceased wife. It is further alleged that his property was sold after his wife was murdered. He used up all of his money, and although also throughout provided money to accused 2. The accused stated that he also lived on the streets for a period of almost 2 weeks. He was arrested at KRKH Ministries and charged. He was detained in Krugersdorp prison for a period of almost 3 months. He has since July 2016 been detained in Johannesburg prison. According to the accused, he has been detained in a single cell. He has requested that he be sentenced to Johannesburg Sun City Prison, as his family is familiar with the prison and will continue to support him. The accused stated that he has requested to pursue with his studies once he is sentenced. He knows that the prison will support him and provide him with the opportunities to pursue with his studies once he is sentenced. According to the accused, he has requested to be transferred to the C maximum to pursue with his studies. Accused as a person, the accused appears to have a quiet, more introverted type of personality. The accused as a young child never manifested any behavioral problems. He excelled in schools and tertiary education. Family orientated, believed that he was used and hypnotized, drugged by the company that he was exposed to whilst they were visiting the co-accused, accused 2. His family members still support the accused. The accused is able to socialize. He has, despite his abilities to socialize, not many friends. Per the accused, he now realizes that he was isolated whilst he was associating with the co-accused and their friends. According to him, this has affected his relationship with his family members and society in general as he became more isolated. He does not make use of any dependency substances. He admitted to drinking on social occasions. He admitted smoking dagga whilst in London, as it is alleged that it was prescribed for him to control his diabetes. According to the accused, he also appears to be a very private person. He needs space around him. The accused made a list of characteristics he found to describe him best. As per the accused and his parents, he is respectful, loyal and self-sacrificing. Peacemaker, kind, soft-hearted, loving, patient, and puts other people's needs before his own. Persistent, giving, gentle, and naive. Intelligent and nurturing. According to the accused, he spent most of his money on what he was told or believed by accused 2. He believed that the money was used for a good cause, to assist people in their cause against Satanism. According to the accused, he was in no position to do the things that he was accused and convicted of. He was involved in the outreach programs at KRKH Ministries. He fed the poor, prayed for the people who required religious intervention, and fed 200 people on a weekly basis. The accused was diagnosed with diabetes almost 21 years ago. He received his medication and needs to inject himself on a daily basis. The undersigned is not a specialist within this field. The information is merely provided to assist. Sources consulted, parents confirm most of the information. They will support the accused in all possible ways. They will never accept that he has engaged in the crimes that he was convicted of, nor a part of who they know the accused is. After he engaged in the co-accused, they believed that he was abused for his income and that he was able to offer them financially. According to them, he grew up in a church. Because of them, the co-accused, he lost his friends, gave up playing drums in his involvement in the youth at the church, and became non-existing. Begged the court for mercy. Crime and previous criminal involvement, possible risk factors. The state advocate was more than willing to assist. The undersigned was provided with a copy of the judgment. The undersigned was not informed of any previous convictions. According to the accused, he is a first offender. The accused pleaded not guilty. His version was rejected by the court and he was subsequently convicted. His rejected version will therefore not be repeated. According to him, he was implicated by some of the co-accused who have already testified. The police were under pressure to bring some people to justice. According to the accused, he believes that the investigating officer promised to assist them. The co-accused who have already pleaded guilty with a few years off or later sentences, they should implicate the accused. The undersigned will not repeat the version of the accused as it was already rejected by the Honourable Court. The accused believes that he was framed and that someone had to be implicated in bringing some closure to a very public case. She is merely providing information as received by the accused and his family members who support him. Per the accused, the media has a tremendous impact on the trial and has jeopardized their chances concerning a fair and a just trial. It is further alleged that the newspaper, a magazine, and the writer has religiously been to court to provide feedback. Per the accused, they are seeking sensation and publicity to sell their story at their personal expense. The accused has throughout maintained his innocence, stated that his only involvement with the co-accused was to pray for her and to assist her financially. He now regrets that more than anything else. He met the accused too many years ago when she attended a church in Western area to come for help to be freed from evil spirits. The church and the members of the congregation prayed for her. The co-accused denies this in totality. The accused according to the accused, the only remorse that he is able to express is that he got involved with the co-accused, that's accused number 2, in the first place. The facts concerning the case are at the disposal of the court. Cognizance was taken of the contents of the crime and related factors and will for purpose of the report not be repeated. The accused has shown no insight and no remorse, cannot express remorse for a case he did not commit. The contact details of the deceased family members were not made available. A report request not required. Judgment. The accused is standing trial as accused number 1. He was convicted on 31 counts being racketeering, intimidation, willful causing of explosion, malicious injury to property, murder, conspiracy to commit murder, robbery with aggravating circumstances, fraud, theft, defeating the cause of justice, possession of an unlicensed firearm, and unlawful possession of ammunition. The accused was not convicted on count 2, counts 22 to 30 not guilty.
Just on that, isn't there a mistake in your report because he was charged with 31 counts? Because at the bottom, I think you say that he was not convicted on count 2 and counts 22 to 30. So that when you say that he was convicted of 31 counts, that can't be correct. If he was found not guilty of counts 22 up to 30 plus count number 2.
Yes.
You see that?
Yeah, no, I see that, my lord. Thank you. 3 of the accused persons either entered into a plea bargaining with the state and 1 pleaded guilty. They were sentenced to various terms of imprisonment. 11 people were murdered over a 4-year period from 2012 to 2016. The accused 1 denied all involvement. So many people were affected by their deeds, witnesses and related people. Accused 1 was a very poor witness. Evaluation. His personal circumstances have been outlined to the court. The community's recognition in the sentence is imperative and should be evaluated and balanced against the seriousness of the offence in question. The sentence option should ensure that the accused will not repeat this type of an offence and that others will be deterred by the sentences imposed by the courts. The accused has since been arrested, charged and is currently being detained as an awaiting trial prisoner. The accused pleaded not guilty. He was convicted after a trial. The facts were placed before the court. The version of the deceased family members were not required for this report. The accused denied all involvement. General information. In suggesting a suitable sentence option for consideration by the Honourable Court, one endeavours to arrive at a sentence that achieves the aims of punishment, deterrence, retribution, rehabilitation and prevention by having regard to the interests of society, the nature and seriousness of the offence in question, and the individual circumstances of the accused blended with a measure of mercy. A just sentence must not only aim at preventing a particular accused to re-offend, but also to deter other would-be offenders from committing offences. The object of sentencing is not to satisfy the public opinion, but to serve the public interest. The interests of society can also be viewed from a social perspective. This perspective will support the efforts to keep a person who is not a threat to society and can fulfill his responsibilities towards his family and society within the society as far as possible. If removed from society for a long period, certain difficulties are expected in readjusting in society, and quite often a person becomes a burden to others and the same society. Retribution, general information. Another goal of a fair sentence is to provide punishment or retribution for the wrong which was committed. An accused person must repent for the harm he has caused. The accused cannot undo his wrongdoings and still denies any involvement. Remorse. It is a known fact that there is no tool to measure true remorse. In this particular matter, the accused did not express remorse or insight. Remorse, as the undersigned understands it, is not to be equated with and does not involve a necessary component of admission or to having committed the offence of which the accused was convicted. If this was a requirement, then no convicted person would ever be able to appeal a conviction or sentence. Such an approach would ultimately infringe on that person's constitutional right to an appeal. Rehabilitation. The accused can enroll in programs and therapy. Treatment is also available within the prison environment, although not specified. Rehabilitation punishment would deter the accused from further criminality. The following factors regarding sentences were considered. The accused is the first offender. He was convicted after a trial and detained. Seriousness of the offences and the minimum sentence options on more than one charge which is applicable. Sentences already imposed for the co-accused whom have since been sentenced. Increase and escalation of aggressive and violent crimes in South Africa. The totality of the crime and the people affected by the crimes. Seriousness of the offence, loss of a life, more than one victim that cannot be replaced, impact on the family members and the community in general, the manner in which the people were killed and the motives behind the killings, no insight and no remorse. In setting out an available sentence option, I do so from my perspective as a social worker, probation officer in the context of the relevant facts, and keeping in mind that this report will form part of the record, should it also be of assistance to any court that may reconsider the findings of this court. It is not my task, but that of the Honourable Court, to decide on an appropriate sentence and the legal competency of any particular sentence option. A non-custodial sentence, negative. The seriousness of the offence committed would outweigh any of these sentence options on its own or combined. Minimum sentence, life imprisonment, is applicable. Seriousness of the offences, loss of many innocent people's lives, lack of insight and remorse, totality of the charges that he was convicted of. Custodial sentence, general information. The purpose of imprisonment are said to be threefold, namely to punish the offender, to prevent further crime, and to rehabilitate the prisoner. In this particular case, a minimum sentence option of life is applicable. Direct imprisonment. The court will in all probability consider a period of direct imprisonment. The accused was informed thereof. He has requested to be sentenced to Johannesburg prison, CMAX, where he would be in a position to pursue with his studies. The term considered will be determined by the Honourable Court. He has denied all involvement, stated that he was merely implicated by the witnesses so that they could benefit in receiving a lesser sentence, and has, as indicated, shown no insight and no remorse. Recommendation. It is accepted that sentencing is a matter which falls within the discretion of the Honourable Court. It is respectfully recommended that the sentence, which reflects the seriousness of the offence, consider the interests of society, but also be fair to the accused and blended with a measure of mercy be imposed. No specific sentence option was suggested, as it is merely an opinion and vests in the hands of the Honourable Court. The undersigned is, however, of the opinion that direct imprisonment would be a suitable sentence option. Then it's only my signature on the page, my Lord, and the sources consulted with. The accused is state advocate for the accused. The documentation as received by the state advocate, judgment, mother and father of the accused, co-accused 1, and general impressions.
Ma'am, the contents is being correct.
That's correct, my Lord.
I just have a few points I would like to clarify from your report, ma'am. First of all, how often on a monthly basis do you visit prisons? Estimated.
That would depend, but at least 7 times, my Lord.
And since the minimum sentencing act has been enacted in has been in action, has decreased the amount of people sentenced to long-term prison. Have you seen a decrease or an increase?
I would say an increase, my lord.
And then, if we may move to the interview you had with the family of the accused, that would be only his mother and his father.
That is correct, my lord.
And that is contained in page 7 to 8 of your report, what you interviewed, the effected or the outcome of your interviews contained.
That is correct, my lord.
Now, I do not see any reference to the effect that this conviction of the accused, number one, has had on his parents. Could you maybe elaborate? Are you in a position to say anything about that?
Yeah, the reason I did not put it in, my lord, is they are also not present today, and they've also stopped coming to the court. They felt that it was tremendous exposure for the family and that they as parents could not deal with it. It also impacted on the positions that they held.
So in the community, they experience problems themselves,
They do experience problems, my lord.
but they are in support of the accused. Whatever happens to him, they will be there for him.
They express that they are 200% in support of the accused and that they will support him.
And Mr. Court, my lord, I have further questions.
Just for clarity's sake, does a court take into account what effect a conviction will have on the accused parents?
I think all circumstances should be taken into account, my lord. The personal circumstances of the accused, but often, my lord, and lately we find that some of the, I would say, the circumstances surrounding the offences are so horrific that even me, in my position as a probation officer and a social worker, have questioned the validity of the reports. But as far as I know, the circumstances of the accused, his personal circumstances, is one of the factors that needs to be taken into account. Then the community at large, and thereafter the seriousness of the offence. And then also the other factors mentioned to the Honourable Court. But that cannot outweigh or never outweigh the seriousness of the offence.
And I think my question is that, do I have to take into account what impact the offences that accused number one was convicted of has got on his parents?
I wouldn't say directly, my lord, but one can say that they have, in the true sense of the word, remember, my lord, I evaluate all of this from a social worker's perspective. So I do not only focus on the facts which I can never memorize, which are already before the Honourable Court. But the mere fact that we do communicate with the accused reflects automatically the fact that his family and extended family has been affected. In the case of his parents, who are truly, I think they are very middle class, upper class, normal people that you would come across with on a daily basis. They have also, to a certain extent, become victims of the circumstances. And I do not say that that would be such a big factor that, no, the accused can or will not be sentenced. But I think it does, for a social worker doing the report, have an impact on the totality of the circumstances.
Anything else, Ms. Snell?
No, thank you.
Mr. Kutzer?
No questions, my lord.
Ms. Johnson?
No questions.
Mr. Roberts?
Thank you, my lord. Mr. Sophia, if you look at the page 3 of your report, you refer to the state advocate concerning the pre-sentence report. That was the person who requested the report.
That is correct, the state advocate for the accused.
No, no. There's the first problem. It's not the state advocate who's appearing for the accused. It is Mrs. Nell, Advocate Nell, who's appearing for the accused. The state advocates in this matter are myself and Advocate Skutter. So that is a wrong impression created there. Do you agree?
Yeah, it's a manner of writing, my lord, so it is the advocate for the accused, and I apologize if it had impacted incorrectly.
Now, on the page 4, you refer to the other side, that also the opportunity to make use of the assistance of an APO. What is APO?
It's an assistant probation officer.
Is that one in training, or what is that?
No, it is a person appointed to assist me with my work when I go out, to assist with interviews, and maybe if I do not ask all of the questions, or should I forget to focus on something.
So you were actually a team then, so to speak.
We function as a team, my lord.
At the bottom you refer to you had on 2 different occasions you went to see the accused, is that correct?
That's correct, my
In
lord.
prison, how long periods did you see him?
Sure, my lord, we are also restricted, but none of these times were less than an hour.
So basically what you say, it was 2 hours consultation with the accused.
No, I did not say it was 2 hours consultation with the accused. I said it would be a minimum of an
The
hour.
maximum?
Maximum, because we are restricted to facilities, I would say 2 hours, my lord.
So a maximum 4 hours. Do you agree?
That is correct, my lord.
And you in agreement that accused number 1 shows no sign of any remorse?
No remorse, my lord. I've indicated that in my report as well, and no insight.
Do you regard that as problematic, that he shows no remorse?
No, it's merely the first question I always get in court, my lord. But it can be a factor because it would also reflect concerning his abilities for future prognosis. But then again, my lord, there is no tool to measure true remorse, and it is also his constitutional right not to express remorse.
Yeah, we'll get to that interpretation you have on remorse at a later stage. Do you agree with me that if we compare the accused number 1 with the general public in South Africa, he had a privileged upbringing?
Absolutely, my lord. It's not disputed or denied.
And he was also a high earner, as you've mentioned,
That's correct,
with
my
above average income for the number of years of experience he had.
That's correct, my lord.
Now, throughout your report, you never dealt with substantial and compelling circumstances.
Most of the compelling circumstances and substantial is the legal terminology and is not really addressed unless there are factors available to us to be highlighted. We do not go into the substantial and compelling circumstances.
Now, I want your views. Do you agree with me that there are no substantial and compelling circumstances in this matter?
My lord, again, it's a legal technicality because the advocate for the accused might feel that the mere fact that he is a first offender can be a factor to be mentioned. And I'm not here to say that there are factors, yes, or pluses or minuses. I think that will be addressed to the Honourable Court.
But you are dealing with mitigating factors and aggravating factors. Why don't you deal with substantial and compelling factors?
My lord, you can't. I did not go into the facts of the case, as the accused have already been convicted. As I've mentioned earlier, sometimes you, as a probation officer, look at the circumstances before you, and there is no reason. The seriousness of the offences are so overwhelming that growing up in a normal home does not balance on the scale.
Yes.
And
So-
it is not really necessary to mention those factors to the Honourable Court because it is obvious that you cannot, because he was brought up in a proper home or he had everything behind him, weigh that out to the seriousness of the offence.
But you agree with me, there are no substantial and compelling circumstances, taking into account his specific circumstances. That's what you've been asked to address.
No, that's not what I'm asked to address. I'm there to address a report on the accused person, not specific, only substantial and compelling evidence. Then, my lord, again, you do not take every situation into consideration. As far as I know, that there was a judgment that said there aren't specific factors to be pointed out as mitigating or aggravating factors. So you cannot ignore certain things just because you think it's not important or it is there. And it's not for me to address the court on those aspects.
But you have done that.
I think what it put you is that if one looks at the report, there are no substantial and compelling circumstances. Do you agree with that or not?
I would say the fact, my lord, while we were talking about the prognosis of a person, that would be to his benefit. The mere fact that he grew up in a very stable home, the mere fact that he had almost everything of the best growing up, the mere fact that he was able to engage in proper education, the mere fact that he had tertiary education, and that the fact that he had never had a pattern of problematic behavior.
Maybe you don't understand substantial and compelling circumstances. As you've mentioned in your report, most of these crimes, the Minimum Sentence Act are applicable.
That's correct, my lord.
Which means that if no substantial and compelling circumstances are being found by the court, life imprisonment or the maximum minimum sentence must be imposed. So now my question to you are the following. Can you think of any substantial and compelling circumstances why the minimum sentences should not be imposed?
Again, my lord, I'm speaking from a social worker's perspective, not a law perspective. And the factors which I place before the Honourable Court are things which I can find from a social worker's perspective, not legal terms and legal terminology.
Is minimum sentence, is aggravating circumstances and mitigating circumstances legal or social work?
No, it's combined, my lord, but from a social worker's perspective, the factors mentioned to the Honourable Court, the fact that he is a first offender, but none of that can outweigh the seriousness of the offence. That can never be denied or disputed.
So you don't want to venture on, if you think there might be some substantial and compelling circumstances to be taken into account by this court? You don't want to go there?
I have nothing in addition to what I've already said, my lord.
Then I put it to you that there are no substantial and compelling circumstances in this matter.
I cannot dispute that, my lord. That would be the State Advocate's address to the Honourable Court.
On page 11 of your report, the second bullet there, under paragraph 5, family orientated believed that he was used, hypnotized or drugged by the company that he was exposed to. Did he elaborate on that version?
No, not really, my lord. It was just how he saw things, the totality of thereof.
Have you read the judgment of the court?
I had your wish, my lord, but I did not make a study thereof because it is quite a few pages. I have it with me.
I want to just take on that with reference to remorse. I don't understand what you mean there at page 19 of your report under remorse. On the one hand, you say in a particular matter the accused did not express remorse or insight. I'm in agreement with you there. Then you go further, and that second paragraph, which I don't understand. If you can just explain that to me.
Remorse, as the undersigned understands it, is not to be equated with and does not involve a necessary of of it's right to say that I don't have remorse, I don't have insight. I did not do this.
Yeah, but there is, what is the meaning of remorse?
The remorse can be manipulated. If I would see that the court deems it very important, I would show remorse from day one, because that is what the court would want to see. At least he's honest and he says, I don't show remorse. I have no remorse for what I did because I didn't do anything.
Yes, he shows no remorse. But then you carry on. If this was a requirement, then no convicted person would ever be able to appeal a conviction or a sentence.
Yes, because then everybody would say, I have remorse, I'm sorry, I've committed the offense.
No, but the court will determine whether it's genuine remorse or not. I don't understand that paragraph, but be that as it may, the mere fact, and I agree with you, he has shown no remorse whatsoever.
No remorse.
And no insight into his situation as well.
That's correct, my lord.
Are you saying that he shows no remorse because he maintains his innocence?
That's correct, my lord.
So to show remorse for something that he believes is innocent would just be partial. It would basically just be a lie.
I do not understand, my lord.
You're saying that he says that he shows no remorse because he maintains his innocence.
That's correct, my lord.
Now, if he was to come and pretend that he's remorseful, that would really be not any remorse. It would just be to try and
Evoke
persuade to the
sympathy.
court that he's remorseful for something he hasn't done.
That's correct, my lord. And then the Honourable Court will, the first question will be, why are you showing remorse for something that you've pleaded not guilty on and said you did not do? It just wouldn't make any
And
sense.
is there always a conflict that an accused person has got?
I think in almost 99% of our cases that's true, my lord.
Yes.
Thank you, my lord. During your maximum 4 hours consultation with accused number 1, did he show any emotion? Because why I'm asking you this is during the whole trial, which lasted a couple of months, the accused number 1 showed very little emotion.
I think we see him in a different way. So you do not only have the formal court environment, and you can speak about a lot of things. The only times that he did show emotion and that he was actually very positive about was when I spoke about his parents. So there was a change in his behavior, yes.
Did he become emotional when he spoke about his parents?
Not emotional, but I think he has a close relationship to a certain extent with his parents.
But as far as the victims in this case are concerned, no emotion whatsoever.
No emotion and no remorse, not concerning the crime, my lord.
I want to put it to you, in the absence of any compelling and substantial circumstances, the only applicable and appropriate sentence for accused number 1 on the majority of these crimes will be the minimum sentences.
My lord, again, I'm not here to make a specific sentence option to the Honourable Court. I've put that on more than one paragraph, and that should be the State Advocate's address to the Honourable Court, and quite so.
Yeah, but you agree
I
a
can-
long-term in custody is an appropriate sentence.
I've already stated in my recommendation that direct imprisonment would be a suitable sentence option. I'm not here to be prescriptive towards the Honourable Court.
I have no further questions. Thank you, my lord.
Any explanation?
None of the court is my lord.
This court also heard evidence that after accused one's wife was killed, and when he went to the crime scene, it showed also no emotions. Do you want to comment on that?
No, I can only take note of it, my lord.
And I'm a bit confused. I think you've got here that he was earning an amount of 75,000 rands a month.
That's correct. That's according to the accused, my lord.
But I think the accused, I'm speaking on correction, had testified that he spent more than 100,000 rands a month towards the orphanage that accused number 2 had told him existed.
That's correct. He had different.
The discrepancy then.
No, he had.
He was earning 75,000 rands a month, spending 100,000 rands towards the orphanage. I don't understand.
He had a different position then, my lord, because the last one where he was earning approximately 70,000 was just for approximately 2 months.
Which company was that?
That was his own forex company, my lord. So prior to that, he had a much higher income.
And he was still working as a financial
That's correct. I've
advisor.
put to the Honourable Court that it was only for about 2 months and that he earned that income. That was on page 9. I did say whilst working at these companies, but that was after he had left Discovery and ABSA. So he was working for himself at the Forex, and it was only 2 months.
Because I thought that, and the record will bear it out, but I thought that he was working for, started his own company. I might be mistaken about that. I think 2015. So it doesn't make sense. If he was earning 70,000 rands per month, he was still at starting 100,000 rands a month towards this orphanage. There's something missing here.
Yeah, no, I take note, my lord. I cannot clarify it because that's the information as I've obtained it.
Also, I think his mother-in-law had testified. That's now the mother of Michaela Valentine had testified, and it said that a year after the death of Michaela, she had sent accused number 1 an email, indicating that she had forgiven some of the people. At some stage, she had thought that Dries, who was the husband of accused number 2, was involved, and I thought that John Barnett himself was also involved, but later discovered that they were not involved. But she'd said that she'd forgiven them, and accused number 1 had responded to, and it said that he feels quite bad that he didn't take enough steps to have protected Michaela from this. Did that ever arise when he consulted with you?
My lord, I did not really focus on that as, again, he was convicted of that. The accused himself expressed that they had a good relationship and that he regrets not being there, that he could have protected or prevented it from happening. But because I did not go into the facts of the matter, I did not put that forward to the court.
Ms. Nell, any questions from mine?
It's a good reason.
No, any questions from mine? You're excused, you may go.
Thank you, my lord.
Ms. Nell?
The evidence from the accused one.
Mr. Kutzer?
Lord, I do not know if the court would take a tea right now.
No, I think I mentioned earlier that because we started late, I was not going to take a tea break. So.
Thank you, my lord. As the court pleases, I wish to recall court back to the stand, Ms. Annette Vergeer.
Is that not for accused number 2?
For accused number 2, my lord.
Can you please state your full names and surname to the court?
It is Annette Vergeer, my lord.
Do you have any objection in taking the prescribed oath?
No, my lord.
You swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth. Please raise your right hand and say, so help me God.
So help me God.
Witness is sworn in, my lord.
Mr. Kutzer?
As the court pleases, Lord, I request you hand up the report. That would be exhibit triple U for uniform.
Yes. It's 5 U's. He said triple.
The 5U.
Yes.
My apologies. Mr. Verkeer, just for the record, can you please state your qualifications and your employment again?
Okay, I have completed BA Social Work Honours at the
I think it
University.
will be necessary because it's not, her qualifications have not been disputed.
Unless you received something by SMS that you've been awarded. That's a court, please.
I think let's not go on to the issue of SMSs here. I've heard too much
That's a
about
complete-
SMSs.
Mr. Verkeer, you compiled the support of which your signature is at the bottom of the report, correct?
That is in fact so, my Lord.
Will you proceed to read the report into record?
I will start on page 4 again, my Lord.
Yes.
On instruction from a state advocate at state expense, I'm not sure if I'm going to be crucified for that again, my Lord. It's the advocate for the accused then. So I apologize in advance. A request was made for a psychosocial pre-sentence report in respect of Mrs. Steyn, hereinafter referred to as the accused. The accused circumstances have been investigated and the following report can be submitted. This report was based on information obtained through an interview with the accused in prison. The undersigned also had the opportunity to make use of an assistant probation officer to clarify information and to assist where applicable. Sources consulted with are attached. Opinion is based on information obtained during the time of the different interviews and subject to review following the availability of new information that might not have been available during the time of the initial interviews. For purpose of this report, little information again could be obtained in an attempt to assist the court. Most of the information obtained could not be confirmed or verified. The undersigned went to see the accused on 2 different occasions in prison. She also went to see her parents on the plot at their place of residence. Different versions of almost everything that I have disclosed were obtained. Complicated contents of the report. Accused Cecilia Steyn, born 22/12/1980. My Lord, may I just have permission from the Honourable Court? The accused was extremely upset on a previous occasion when the names of her children were exposed in court, because what had happened, the people went to the schools and the children, it's alleged, were exposed. Can I just keep it there for paper purposes then?
Yes, I think don't mention, their names.
Thank you, my Lord. Son of the accused, born 12/6/2003. He's 16 years old. The accused has no contact visits with her child, visits through the glass window. Her son resides with his father. He's a grade 10 student at Johannesburg High School. Children are severely exposed and affected because of the media with coupled consequences. Louisa Helena Johanna Steyn, daughter of the accused, born 18 January 2007. She's 12 years old, resides with her father. She attends a Glen Harvey Primary School, grade 7 student. The accused has no contact visits with her child, visits through the glass window. The children are severely affected and exposed because of the media with coupled consequences. Relationship aspects. First marriage. The accused stated that she engaged in a marriage relationship many years ago with an immigrant to secure a green card for him. The couple never stayed together and had no children. According to the accused, they were only married for 4 days. She did not maintain contact with him. Second marriage relationship, per the accused, she was married to a previous husband during 2003. They were married for almost 15 years. According to the accused, she was not really interested in the marriage relationship and just wanted to have children within a safe and secure relationship. Despite being married, it is alleged that they lived separate lives or apart and had separate bedrooms. It is further alleged that despite the controversial arrangement, both parties expressed their love for one another. Her previous husband has since obtained full custody and control over their 2 minor children. The accused was arrested on the 23rd of July 2016. It is alleged that she then resided in the same house as her previous husband, but with a lazy friend, engaged in a lesbian relationship, stated that she never really disclosed the details with her husband and children. Her previous husband still comes to visit the accused every Tuesday and Thursday at the prison. He provides emotional and financial support. He is often accompanied by the children when they are able to visit the accused. The previous husband, as mentioned earlier, obtained full custody and control over the minor children. The accused was therefore not confirmed to be a sole caregiver or primarily caregiver provider concerning her minor children. Parents of the accused. According to the parents of the accused, they were expressing they were expressing support for the accused. The mother of the accused also provided information different as received from the accused in an attempt to assist her or the accused. The accused, however, made it clear that she would want the children to remain in the care of her husband and not the care of her parents. Background circumstances. The accused was born in Harrismith, where after she was raised and mainly grew up in different areas, maintained a nomadic lifestyle. The mother of the accused has never managed a working position. She is a housewife. The father of the accused previously managed a working position as an electrical inspector on the mine. He has since retired. The father of the accused has part-time and temporary working positions. It is alleged that both the parents receive a SASSA grant. The accused was born one in a family of 2 children. Her older sister was born from her mother's first relationship, and it is alleged that she has since been arrested on another criminal matter, possession of drugs and firearms, in Western Area Court. Details and status of the case not disclosed. The accused and her mother maintain different versions concerning her background and homely circumstances. From the interview, it appears as if the accused was exposed to an extreme and difficult homely circumstances. She was provided, confirmed, and denied some of the information at the same time. Her mother had a different version altogether. Her father appears to have been an aggressive type of a person who abused him physically and emotionally. It is alleged that the mother of the accused was forced to stand up to ensure survival despite remaining with him. According to the accused, the abuse has since stopped, less frequent. Because of the contradictions concerning her family background and circumstances, the information as received does not appear to be relevant, as almost all of it was either disputed or constantly amended by the concerned parties. Her parents expressed their concern for the welfare of the minor children. The accused did not appreciate her parents' concern or involvement with the children. Her parents, however, begged the court for mercy for the accused. School and work record. The accused attended 4 different primary schools. She was placed in a boarding school. She completed grade 7 at Hillshaven Primary School. She proceeded to Vanderbijl Park High School. The accused then enrolled in Western Area High School. She was suspended during her grade 10 school year. According to the accused, she was making use of alcohol on the school premises during a sports event. Her mother alleges that she completed grade 12 and pursued with a tertiary education. According to the accused, this is not true, and that her mother knows that she was suspended. According to the accused, she left school at the age of 15. She has completed grade 9, standard 7. The sister of the accused has since moved out of the family house. It is alleged that the accused and her sister have maintained a close emotional bond. The accused went to stay with her after she had left her parents' home. According to the accused, she only managed to obtain 1 working position at a creche after she had left school. She engaged in a marriage relationship thereafter and did not obtain employment again. The previous husband of the accused manages a working position at the South African Police Services. He supports the accused financially in prison. He also provides general support and allows her visits with the concerned children. According to the husband of the accused has always been a straightforward person. He believes that she is also honest. She's a wonderful friend and a mother to her children. He believes that she has been framed and implicated. Nothing that has since transpired within this case were ever evident throughout the years and that they have been together. He will never believe that she was involved in the crimes. According to him, there were not enough evidence and people were forced to implicate other people. Their children have severely been affected in all possible ways, emotionally, in public and in the schools, by everything that transpired so far. Traumatic experience for them. His son was only 12 years old when his mother was arrested. He has since become an angry and aggressive child. They do not understand the judicial processes. Children become the victims. They were married. The accused was always at home. According to him, she never engaged in social events that he is aware of. They have all been affected and traumatized by the outcome of the criminal matter. His children were and still are exposed at school. It has affected their academical performances and participation in sports. They are constantly exposed in public. Children and members of the public would come up to them and tease them to make rude remarks at them. They were forced to become isolated. His son used to play Gauteng sport. He no longer participates despite being one of the top 44 players. The accused has since been arrested and detained in Johannesburg female prison. According to the accused, she has managed to build positive relationships with many of the wardens and inmates in the prison and in her cell. The wardens had brought the accused through for the interviews, confirmed no problems with the accused during a time of detention. They have only spoken highly of the accused. They did not wish to be exposed for purpose of publicity and exposure. She has since obtained 3 different letters from inmates concerning her positive attitude, her involvement in support with the inmates, and a positive influence on the people in general. The accused has been detained in the hospital section from the onset of her admission and coupled detention. It is alleged that she came in with her mother's oxygen tank and is being monitored. According to the accused, she will not appeal her sentence for now. She has terminated a friendship with her previous girlfriend and has since engaged in a lesbian relationship with another inmate who is serving 15 years sentence for murder. The accused never once complained about the circumstances in which she finds herself. She has, however, expressed concern about her children and their homely circumstances. The accused appears to have an outgoing, more of an extroverted type of personality. The background circumstances of the accused could not be verified. According to the accused, she came into the hospital section with her own oxygen tank, the mother's oxygen tank. According to the accused, she has experimented with dagga and cat once while schooling. She cannot really drink because of her health factors. She has been diagnosed with asthma from the age of 16. She uses an asthma pump and oxygen as required. Her medication is currently provided by the previous husband of the accused. The accused was also diagnosed with epilepsy from the age of 8. She uses prescribed medication. The accused also has confirmed bleeding ulcer. She takes medication for cholesterol. According to the accused, she receives the medication in the hospital. There is a sister on duty who provides the medication. The husband brings, it should be the ex or the previous husband brings the medication to prison. They are also being monitored by a medical doctor. The accused has since been detained for the past almost 3 years. According to the accused, she wakes up every morning at 5. They take part in the parade to count the various inmates. They have breakfast and medication at around 9. According to the accused, she normally reads a book and do washing before they have lunch at 12. The accused and the other inmates are then locked up around 12 after lunch, and the lights in the cell need to be switched off by 10. They are allowed to socialize within the cell, no restrictions. The accused has confirmed that she saw her son once because of his aggressive behavior at home and at in the school. They only had one contact visit, and the balance of the visits were conducted through a glass panels. The social worker is currently assisting her concerning her children. The accused, despite the adversity of the circumstances, appears to have adopted well within the prison environment, excluding personal circumstances, children, and her previous husband. She has never once complained about anything relating to her detention and was confirmed to be a model inmate. Effects on the case of her children. The accused confirmed that the children are not allowed to attend the court case, protect them. They have since been forced to live an isolated lifestyle survival. It is alleged that the media has on occasions visited the schools. Her children were protected by the school. According to her, the names of her children were disclosed in court. The public exposure. The children have severely been traumatized, lost their mother and needs answers. Their father attempts to protect them. She speaks to them through a glass panel, but there's little comfort for children whom have become the victims of circumstances. The media and sensational exposure are the worst for her and the family members. It is as if they were granted power over and above everything else to expose and destroy people whom they know nothing about with no consequences. Satanism. The accused denied all involvement in Satanism. Information were placed before the court, but according to her, have no relevance to the case. She confirmed some of the information that were placed before the court by the concerned parties. Her alleged role in Satanism. None of the information, according to her, could be confirmed, except for what was said by the witnesses or used against her. Prison environment. The accused, as mentioned before, has since started to adapt within her current situation and circumstances, stated that she felt caged in the beginning but has since managed to adapt and overcome her fears. It is very easy to comply with the routines and the set rules. She attempts to concentrate, needs to be in control of her emotions and thoughts. She has an excellent support system within the prison environment. Sources consulted. Parents confirmed they contradicted most of the information. They will support the accused in all possible ways. They will never accept that she has engaged in the crimes that she was convicted of, not part of who they know the accused is. According to them, they were informed that more people will still be brought to justice concerning these cases. Beg the court for mercy. Crime and previous criminal involvement, possible risk factors, crime. The state advocate was more than willing to assist. The undersigned was provided with a copy of the judgment. The undersigned was not informed of any previous convictions. According to the accused, she is a first offender. The accused pleaded not guilty. She has maintained her innocence. According to her, she was implicated by some of the co-accused who have already testified. The undersigned will not repeat the version of the accused, not relevant. The accused was never once blamed any of the co-accused, newspapers, or any of the role players for her current situation. According to her, she cannot plan a crime and make people do certain things. She totally denied any involvement. The accused throughout maintained her innocence. She has projected an unrealistic acceptance of her adverse circumstances, indicated that she will not appeal a sentence for now. When pressured about the current disposition and the accused became more emotional, the undersigned indicated that she could not write a report about her as it could possibly affect her negatively. The accused then said that the judge should call upon God to come and testify if they are not content with her version. Facts concerning the case are at the disposal of the court. Cognizance was taken of the contents of the crime, and related factors and willful purpose of the report not be repeated. No insight, no remorse, cannot express remorse for a case she did not commit or had any involvement in. The contact details of the deceased family members were not made available. Report per request not required. Judgment, the accused is standing trial as accused number 2. She has manipulated and lied to all the people that she has contact with. She was referred to as a psychological liar and highly skilled manipulator. She did not impress as a witness. She abused the generosity of the people who thought that they were making a difference against Satanism. The enterprise was compared to a religious cult where people were misled and manipulated so that these lies later became the truth to them. The accused was referred to as the master of deception and manipulation. She was also referred to as a single common denominator in respect of all of the charges set out in the indictment. The accused was convicted on 32 counts, being of racketeering, managing an enterprise, intimidation, willfulness, causing of explosions, malicious injury to property, murder, conspiracy to commit murder, robbery with aggravating circumstances, fraud, theft, defeating the cause of justice, possession of an unlicensed firearm, and unlawful possession of ammunition. Charges 1 to 32 as reflected in the judgment. 3 of the other accused persons either entered into a plea bargain with the state and 1 pleaded guilty. They were sentenced to various terms of imprisonment. 11 people were murdered over a period from 2012 to 2016. Accused 2 denied all involvement. So many people were affected by their deeds, witnesses and related people. Her personal circumstances have been outlined to the court. The community's recognition in the sentence is imperative and should be evaluated and balanced against the seriousness of the offence in question. The sentence option should ensure that the accused will not repeat this type of an offence and that others will be deterred by the sentences imposed by the courts. The accused has since been arrested, charged, and is currently being detained in an awaiting trial prisoner. The accused pleaded not guilty. She was convicted after a trial. The facts were placed before the court. The version of the deceased family members were not required for this report. Various victims. The accused denied and still denies all involvement. General information obtained in suggesting a suitable sentence option for consideration by the Honourable Court. One endeavours to arrive at a sentence that achieves the aims of punishment, deterrence, retribution, rehabilitation and prevention by having regard to the interests of society, the nature and seriousness of the offence in question, and the individual circumstances of the accused blended with a measure of mercy. General information, a just sentence must not only aim at preventing a particular accused to reoffend, but also to deter other would-be offenders from committing offences. Deterrence, the offender is subject to punishment which will deter the accused and other from further and possible future involvement in crime. The object of sentencing is not to satisfy the public opinion, but to serve the public interest. The interests of society can also be viewed from a social perspective. This perspective would support the efforts to keep a person who is not a threat to society and can fulfill her responsibilities towards her family and society within the society as far as possible. If removed from society for long periods, certain difficulties are expected in readjusting in society, and quite often a person becomes a burden to others in the same society. Society also has a right to be protected from people who impose a risk to them through incarceration and direct protection. Retribution. Another goal of a fair sentence is to provide punishment or retribution for the wrong which was committed. Retribution restores a legal balance which has been disturbed through the commission of the offence. Society does not receive anything concrete from the accused being punished, but the satisfaction that the crime did not go unpunished. An accused person must do penance for the harm she has caused. The accused cannot undo her wrongdoings and still denies any involvement. Retribution resumes moral blame, social condemnation in that the community insists that the accused be punished for the wrongdoings. Remorse. It is a known fact that there is no tool to measure true remorse. In this particular matter, the accused did not express remorse or insight. Remorse, as the undersigned understands, is not to be acquitted with and does not involve the necessary component of an admission to having committed the offence of which the accused was convicted. If this was a requirement, then no convicted person would ever be able to appeal a conviction or sentence, such as an approach would ultimately infringe that person's constitutional right to an appeal. Again, my Lord, I think we're going to have a question here, but it was my understanding that you cannot just come to court and say, I'm sorry, just mere for the purpose of being sorry. So the accused, again, did not express any remorse or insight. Thank you, my Lord. Rehabilitation. Rehabilitation often focuses on the assumption that people commit offences due to the personal shortcomings, specific psychological factors, or negative personal circumstances. Through rehabilitation, people are often assisted to gain knowledge and insight, or to be helped to change from destructive and constructive human beings. The accused can enroll in programs and therapy. Treatment is available within the prison environment, and inmates are motivated to participate. Punishment rehabilitation would deter the accused from further criminality. The following factors regarding the sentence options were considered. The accused is the first offender. She was convicted after a trial, seriousness of the offences, and the minimum sentence option concerning more than one charge, which is applicable. Sentences already imposed for the co-accused whom have since been sentenced. Increase and escalation of aggressive and violent crimes in South Africa. Totality of the crime and the people affected by the crimes. Seriousness of the offences. Loss of a life of more than one victim that cannot be replaced. Impact on their family members and the community in general. The manner in which people were killed and the motives behind the killings. No insight and no remorse. Sentence option. In setting out an available sentence option, I do so from my perspective as a social worker and probation officer in the context of the relevant facts, and keeping in mind that this report will form part of the record and should also be of an assistance to any other court that may reconsider the findings of this court. It is not my task, but that of the Honourable Court, to decide on an appropriate sentence and the legal competency of the particular sentence option. Non-custodial sentence option negative. The seriousness of the offence committed without weigh any of these sentence options on its own or combined. The minimum sentence, life imprisonment, is applicable. Seriousness of the offence, loss of many innocent people's lives, lack of insight and remorse, totality of the charges that she was convicted of. Custodial sentence, general information obtained. The purpose of imprisonment are said to be threefold, namely to punish the offender, to prevent further crime, and to rehabilitate the prisoner. In this particular case, the minimum sentence option of life is applicable. The court will in all probability consider a period of direct imprisonment. The accused was informed thereof. As mentioned before, the accused has projected an unrealistic acceptance of the totality of the circumstances. The term considered will be determined by the Honourable Court. She has denied all involvement and has shown and expressed no insight and no remorse. Recommendation: it is accepted that sentencing is a matter which falls within the discretion of the Honourable Court. It is respectfully recommended that the sentence which affects the seriousness of the offence consider the interests of society, but be fair to the accused and blended with a measure of mercy be imposed. No specific sentence option was suggested, as it is merely an opinion, and sentencing rests in the hands of the Honourable Court. The undersigned is, however, of the opinion that direct imprisonment would be a suitable sentence option. And there is just my signature, my lord. On the attached sources consulted was the accused, the state advocate, documentation received by the state advocate for the accused, judgment, mother and father of the accused, previous husband of the accused, children because of various problems already confirmed have not been exposed, merely for purpose of the paper processes, co-accused 2, and then there were 3 inmates that provided documentation, general impressions.
Thank you, my lord. Ms. Fakir, just for purposes of the record, you agree that where mentioned state advocate requesting the report,
It should be the state advocate for the accused. That's good.
Now, ma'am, in numerous places in your report, you made mention of contradictions with regard to information received from accused 2 and the parents.
That's correct, my lord.
Now, could you drill down and by means of corroboration ascertain which of the 2 versions are the true one?
Not at all, my lord.
So we are none the wiser at this stage who is speaking the truth or not.
That is correct, my lord.
Now, I do not want to preempt what my learned friend for the state will ask you, but in your discussions and in your thinking whilst drafting your report, could you ascertain anything that would be meaningful to act as mitigation in this matter?
Again, my lord, not concerning the accused that I could obtain except for what has been placed before the court. Concerning the accused, I must admit I've never seen somebody focusing on her children the manner in which she is. I can confirm that the social worker has made arrangements for her to see her children, and that she has maintained a very close relationship with them. There has only been 1 contact visit, the rest is through the glass panels. Irrespective, I would say, of her deeds and the aversiveness of what they have done or may have committed, she really focused concerning her children.
I have no further questions. If the court pleases, no.
Ms. Snell?
No questions, thank you, Madam.
Ms. Johnson?
No question.
Mr. Roberts?
Thank you, my lord. Just for clarity's sake, at the sources consulted, you did also not consult with any state advocate?
No, I actually did, my lord.
With whom? Not with me.
Okay.
Let her answer the question first. Who did you consult with?
I did find the document, if my lord will just give me some. I normally just use, I did not specify a name or anything to that effect. Advocate Paul Skitter.
Did you phone him for the judgment? Is that what you mean by
No.
consultation?
No, I did not phone him for the judgment, and that's not what I mean by consultation. I actually phoned him after I've been to see the accused person, and I have discussed the fact that all of the information that I received could not be verified. And that at some point, and the accused is present obviously here today, I was not going to write the report, that I felt that it would almost be a waste of time. I did in fact then decide to assist her in writing the report with the information as that was available.
I understand. Now, you've already mentioned about the contradictions between the family of accused 2 and yourself.
That is in fact so, my lord.
So we, at this stage, cannot refer to her upbringing, whether it was good or bad.
We cannot, my lord.
What bothers me a bit further is that there's also contradictions between accused number 1 and accused number 2. Was that not, did that not make it difficult for you to report on both? Because number one says he's been manipulated by accused number two.
Not at all, my lord, because I focused on their background circumstances. And whether a person is born in 1920, it cannot really be changed. Nowadays, I would say for at least the past 6-7 years, the crimes have escalated to such an extent that I've been called now to Court D while I'm standing here, also for accused 1, 2, and I'm going to write a report on 3 and 4 as well. So unfortunately, there's not enough people available to do reports on each and every person, and it is not a strange phenomenon to us at all.
So are you saying it did not hamper you, the fact that they are contradicting each other, 1 and 2?
Not at all, because I did not focus on that. I had to focus on their personal circumstances.
Well, look, I think in your first report, accused 1 had said that he was hypnotized and drugged by the company he kept, and also referred to accused number 2. Yet, despite that, you also you saw accused number 2, and you didn't raise this whole issue around
No,
being
because
hypnotized and drugged.
she completely just denied everything, my lord, so it wasn't necessary to raise it with her.
Yes.
So the value of the information accused 2 has given you is suspect
That is correct, my lord.
in all its, from the beginning to the end. Because she, as the court found, she was a pathological liar and a master manipulator.
That was in the judgment, that's correct, my lord.
Did you also experience that?
I did not find, she has no reason to manipulate me unless she wanted to by giving the wrong information. But I did not find her, as I've stated again, when we interview people, we are on a different, I do not have to push her for certain information. I do not have to obtain an end result. If she's not forthcoming or the information that I cannot provide to the Honourable Court does not assist the Honourable Court, it would be to her loss. But it's not for me to pressure her at all.
But the fact
But
that
you see, Mr. Geer, accused number 3 had testified in this court in May 13th May 2019. And she didn't enter into a plea agreement with the state, didn't plead guilty. But when she testified, I think she dealt with the role played by accused number 2. And it even said to this court that the reason why she came clean was after she had seen that accused number 2 had lied to them.
I take note thereof, my lord, because I haven't interviewed her.
So it's not just a case that co-accused. I think our own accused person, we had no deal with the state, testified to that fact.
I take note thereof, my lord.
And anyway, I think I've already made certain findings when I convicted her. But from what I gather, I think she blames everybody else except herself. And she says, "No, my parents were lying about this. These people were lying." Is that the impression that you got?
My lord, actually, the impression that I got concerning any of the co-accused, she never blamed or implicated anybody. And I've got that in my report. She never said that anybody did anything. She just withdrew herself completely from the entire situation.
I don't understand that.
In other words, she never said accused 2 did, 1 did this, accused 3 did that. Or she just withdrew herself. I actually asked her that one day, you don't implicate anybody, and she said, I don't. Concerning her background and concerning her circumstances, she and her mother had a total different scenario of what had happened. Her mother, for instance, even said that she went to university, and she had documentation to that effect, but it was never provided. When the accused said, no, I only finished standard 7, which is grade 9, and I was suspended from school from drinking. So there were these personal things which did not add up, so none of it could
I
be.
think in this court too, the impression I think was given that she had certain various, degrees and doctorates and masters, you know. And even if one looks at, you know, the reports, you know, in relation to deity, I think, you know, she was described in a certain position, you know.
Nothing that I could confirm, my lord.
And of course, I think when she testified, she said, I think she only went up to standard 7.
That's correct,
And it
my
had
lord.
denied that she'd said to anyone that she holds a doctorate or master's degree and the rest, you know.
That's correct, my lord.
You may proceed.
Thank you, Manu. You see, the problem is, she didn't implicate anybody of her co-accused because that was the essence of the defense, a bare denial of anything. So she cannot implicate anybody else because then it will imply that she was also aware of what happened.
Yeah.
Because she had this bare denial, therefore she will not implicate anybody.
I
So
take
it's
note.
neither here nor there.
I take note, my lord. She was already convicted.
And the positive remarks from some of the prison authorities, do you think those are genuine or once again manipulated? Manipulated positive input to you?
The wardens themselves shockingly came to us while we were busy with the interviews, and all of them had a positive disposition concerning the accused person. So they came out of their own, my lord. The only thing that they requested is that they will not be exposed because it's from a different department and they did not want to be exposed.
So they want to be anonymous.
That is correct, my lord.
Now, once again, you haven't dealt with substantial and compelling circumstances, and I'm not going to go through the whole scenario again, but do you agree there's nothing from your perspective which we can terminate as substantial and compelling circumstances with regard to minimum sentence?
I do not think so, my lord, but again, from a social worker's perspective, if I leave out the children, irrespective whether we think she's a negative role model or not, her children, while she was out in the community, performed above average, and they accomplished and achieved a lot of things while she was still with them. So I do not say that it outweighs the seriousness of any offense, but from a social worker's perspective, it cannot be denied.
But that's not substantial. That's of a general nature. Many accused of a general nature might have done favorable things in the past, but it must be specific, substantial and compelling to this matter. There's nothing you can think of.
Not concerning the crimes that were committed, my lord.
You said the son excelled in Gauteng sports.
That is correct, my lord.
What kind of sport?
There were more than one. It was cricket and rugby, and there were more than that.
Do you mean by Gauteng, do you mean he received provincial colours?
That is as I understood it, my lord.
Is the accused still married?
No, she's not
Because I
married,
think in
my
your
lord.
report
And
you talk about my former husband. Or
yes, it's the previous husband. She's no longer married, and
did
he
they get
obtained.
divorced?
Yes, my lord, and he obtained full custody over the children.
You don't know when the divorce took place?
No, my lord, I don't have a specific date.
Yes.
It was after arrest. Did you know that or not?
Yes, it was.
It was
after,
after, while she was in custody, they divorced.
that's correct.
You also referred to a lady friend with whom she engaged in a lesbian relationship. Who was that?
I did not take the details down as she's not relevant to be exposed.
Well, she came to court and she claimed that she had she had at least one lesbian relationship. So I want to know whether it's the same person or another person.
I wouldn't know, my lord. I did not expose
No,
her.
the report talks about different people. I thought that some reference made to an
Yes,
inmate.
the last one is a different one. That's correct.
An inmate, I think.
Yeah.
That's the last one. But on page 7, she refers to another lady. But you never asked her about that relationship.
No, my lord.
You deemed it not necessary.
No, my lord.
is it the father or the husband that also believes that she was framed and implicated in this crime?
That is her previous husband. That's correct, my
Yes.
lord. That's correct, my lord.
What's her view?
Who would be who? I don't
Accused
understand.
number 2,
About what?
about being framed or implicated or being in the position she is now.
My lord, she did not express anything on being involved in the crimes at all.
So she never even dealt with that issue.
Not
of the
at all.
crimes.
Not at all, my lord.
She just denied them blankly.
That's correct, my lord.
Even the reference to Satanism, which she also denies, because that was one of the teachers that accused number 1 was relying upon. And that's why I asked you that initial question about how do you work with that initial, that factor which accused number 1 gave you as a reason why he was involved in this scenario, and the blanket denial from accused number 2 regarding that factor, the same factor.
It's very simple, my lord. I'm not here to judge them or to sentence them. I'm just here to give their background circumstances.
I put it to you, there's nothing in the background circumstances of accused number 2 which will be beneficial to her in, when coming to sentence, because none of them can be equated to substantial compelling circumstances in this matter.
I take note thereof, my lord.
I have no further questions, thank you.
Any re-examination, Mr. Kutsa?
Yeah, just one, my lord. Just here, just to confirm, is it not correct that you are not in a position to establish who of either accused 2 or parents is talking the truth?
That's correct,
Correct.
my lord.
And you have, it's also correct that in your report you make no finding of any manipulation from accused 2 side with regard to the drafting of your report. Correct?
If she had not spoken the truth, then that could be a form of manipulation from her side. I did not experience that, my lord.
No further questions, Lord?
You're excused, you may go.
May I
You may
go?
go.
Thank you, my lord.
Is she also going to be called? Is that case number 3?
No.
Okay. Any other witnesses, Mr. Kutsa?
Nothing, my lord. That is the case for Ms.
Ms. Johnson?
I call Mrs. Annelie Skeepers to testify.
Annelie?
Annelie Skeepers.
Skippers.
Can you please state your full names and surname to the court?
It's Annelie Skeepers.
Do you have any objection in taking the prescribed oath?
No?
You swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Please raise your right hand and say, so help me God.
So help me God.
Witness is sworn in, my lord.
Mrs. Skeepers, do you know accused number 3?
Yes, I do, my Lord.
How?
I was married to their father, my Lord,
When did you first meet her?
during 2003, my Lord.
And what is her father's name?
Andre Hugo, my Lord.
When were you and Mr. Hugo married?
November 2003, my Lord.
And at that stage, how old was Marcel?
Marcel was 6 years old, my Lord.
Mr. Hugo also had a son, Leroux, am I correct?
That's correct, my Lord.
And how old was he when
Nothing,
you got...
he still has a son.
Yes.
Yes. Okay.
How old was Leroux when you got married?
8 years old.
Now, can you explain the relationship between your ex-husband and Marcel Steyn during the time just after your marriage to Mr. Hugo?
They were fighting all the way, and then they were constantly fighting.
And how often did you see Marcel and Leroux?
During that time, we saw them twice every weekend, and well, every second weekend, and also some holidays.
And was this arrangement in terms of the divorce settlement?
Yes, it was.
Now, you have testified that the children visited every second weekend. As far as you can recall, was this arrangement stuck to religiously? And can you specify any period that, or the period during which this was the case?
Yes, during 2003 towards kind of middle of 2008, we stuck to that. And we really tried our best to see them every second weekend, and some holidays that was that we could see them.
And at the time, did you have any children of your own?
Yes, I've got a son.
But not witnessed?
No, no.
Now, you've testified that there was these constant arguments between Miranda and her ex-husband at the time. What were these arguments about, and how did they affect the children?
They mostly fight about money and access to the children. Miranda always claimed that Andre didn't pay enough maintenance. She once took him to court because she sued him because she believed, or she argued that he didn't pay some maintenance, but then after the court case was finished, we did pay it. She was always also, they were fighting because she didn't want the kids to call me mother at that stage, and she instructed them not to do so. And she also told Andre that she don't see the need for them to call me mom because they've got a mother, and you know that she just feels it's not the right thing for them, excuse me, to do.
And what was she like with regard to her children?
Very overprotective. She was very overprotective.
Now, when these arguments were taking place, were you present?
Most of it was over the telephone, so yeah, I've heard them, and yeah, Andre also discussed it with me. I can recall the one time when I was present, and that was the only time that I was actually present.
What happened on that occasion?
We went to fetch the children in Krugersdorp. They stayed there, and when we got there, Miranda came out with the children, and immediately she and Andre started to fight about the same stuff. And we were in the parking lot, and it was quite severe because they were yelling at each other. And I could see the children was baffled, and I didn't even know what to do. So I decided, okay, maybe I must just, take a walk with them, just to calm them down, and just to, I just was just thinking, let's just get out of there. And I could see it was really bothering Marcel because she was still young. And then when we got back at the vehicle, I saw that she wet her pants because it was just not doing her good to see that.
Now, what was your relationship like with your stepchildren?
Very good. I really think we had an excellent relationship.
And your relationship with Miranda?
Because after that incident, when Andre and Miranda was fighting in the parking lot, we decided that it's going to be the best that I start fetching the kids. So when I got there, I tried to avoid any arguments for the sake of the children, and that we just keep good with the good roads.
What did she tell you about the reasons for not, or if anything, for not getting along so well with Mr. Newton?
When I fetched the children, she always didn't mind telling me, I saw her quickly because I was waiting for the kids to get the stuff, and sometimes we just sat down and talked, and she said to me that she always came forward with all the stuff what Andre did wrong in their relationship. like he had relations with other women, and that he mistreated her a lot. So I want to ask her now if he was, well, and she said she's now glad that I'm part of their life. So I want to ask her what is the reason? Why did you then marry him if you disliked him that much? And as you said, you hated him even before Leroux was born because of you believed that he had relationships. And she told me that her biological clock was running out. She was desperate to have kids. And Andre met all the criteria. He was attractive. He came out of a good, wealthy family. He was intelligent, and that he met all the criteria, and that was the reason. And she gave me.
Now, what was the specific incident that took place regarding Mr. Lugo's sister and Leroux Steyn?
Andre told me that once his sister, Leroux was only 8 months old when Renee's sister visited him, and she wanted to go to the mall, and she asked Andre if she can take Leroux with, and she did. And while they were gone, Miranda arrived at home, and she was furious. She was very, very cross because Andre let Leroux go with Renee. And she even actually told Renee that she tried to kidnap her kid. And that was what happened there.
And then what happened after that incident regarding Marcel and Leroux and the paternal family?
Andre told me that after that, that I think the family was a bit cross with that, and that they didn't really saw them a lot after that. I once, when Marcel and Leroux was visiting us, I asked Leroux, when last did you see Andre? And he said to me, well, a long time ago, because his mother doesn't like her a lot because of the reason that she tried to kidnap him when he was younger, and that he also don't like her because of that. And they weren't a very family because we really never saw each other that much.
Okay. Now, what about the paternal grandparents of the children? Were they involved in the lives of Marcel?
No, not really.
Did Marcel have a paternal grandmother?
Yes, she had. Andre's mother, she called, the kids called her Oma Lolly. And I recall, I know that and Andre also told me that she had a very close relationship to her Oma. And she visited her, and her Oma taught her how to play cards, and they were doing some makeup together. So yeah. But I also know that when I met Andre, she went also through a divorce. And I think she had a bit of difficulty coping with that, and she didn't saw the kids that much. She never went to fetch them by herself. So whenever we were together, everybody, then that was when she was able to saw them.
Now, you testified already that the children, Marcel and Leroux, visited regularly from 2003 to the middle of 2008, am I correct?
Yes, that's correct.
What happened in the middle of 2008? It changed.
Well, it was like Miranda became more strict, and the kids came to visit us, and we were sitting around the table and talking, and then they told us about the new religion that they are now part of, and also that their mother watched, or I don't know if it was part of the religion or something, but her mother started to burn all the pictures and the statues because she said that demons can possess them or come through them, and that stuff like that will keep them away from God. Leroux was also instructed to get rid of all the, I don't know, but it was like little toy soldiers. So he had to give it to my son because she instructed him to throw it away.
What was the reason for that?
Because she said that that all belongs to the earth, and that earthly stuff will take you away from God, and that it will make demons come into your life.
And anything else regarding their behavior that changed at that point?
Yes, they suddenly didn't want to watch TV. Well, they were not allowed to watch TV anymore because it was, according to their mother, it was bad for them, and that it is a bad influence on them. And also, they were not allowed to read certain books and watch certain movies.
And at that stage, what was while the children were visiting at your place, what was Miranda? You said that she became more strict. In
Yes.
what way? What did she
Well, she always set times for us to pick up the children. And during that time, it was like, if we wanted to pick the kids up, she will have an excuse. And she made it difficult for us. And, we were coming from, we had to travel 2.5 hours to fetch the kids. And one of the things was that she was very strict on was that we had to have them there before the church started, because it was important for them to be part of the church services.
And then, with regard to holidays that you had, or that Mr. Nico had access to the children, are there any specific incidents that took place during any of the holidays?
Yeah, that specific 2008, the children came, we only closed the business around about 20 to 24th of December, and my mother and brother went down to the sea, and they decided to take the 3 kids with. We bought them some clothes, and that is all that my mother then told me afterwards, is that when upon arriving there, she gave them the clothes, Marcel threw some of the clothes in the dustbin because she was not allowed to wear certain brands or certain colors, because it was not according to her mother and the church that they were attending. And also they wanted to take the kids to go and watch a movie, and the kids also said no, they don't want to go and watch the movie because they're not allowed to watch the movie. And again, it was, she told my brother very proudly about this church that they are now attending that is saving people from the Satan.
Did Marcel say anything else to you with regard to, or do you have any knowledge regarding this church that they now do?
No, only that they were saving people.
Now, what happened between the end of 2008 and the beginning of 2009 regarding you and Miranda?
It was also because of we once had to take the children. Well, we had to take the children back on a Sunday, and then between Pretoria and Krugersdorp, the vehicle that we were driving had some problems, so we were stuck next to the road. And Miranda was very furious about that because that's not the agreement, and we had to find people to come and help us. So we only arrived a bit late that afternoon, and well, she was fighting with Andre over the phone and constantly phoning us and blaming us for the vehicle that's broken down. And after we dropped them off at the house, there was a very strange call that came through on my phone. And on the other side was a strange number. The person didn't even try and hide the number. And there was a lady on the other side that told me that, do I know that she's got a relationship with Andre? So I told her, no, I don't think it's possible, because at that stage we were in each other, well, we were together 24/7. We worked together, we drove together. It wasn't possible. And the other thing that also made me believe that Marinda got something to do with it was because the phone that we used at that stage was only, the number was only available to the close family and Marinda and the kids. So nobody really could have had access to the number. And yeah, I then realized that, sorry, it made me scared because I thought, well, I realized that Marinda now was targeting our marriage.
Is there anything else that happened after that incident with regard to your collecting the children or incidents between yourself and Marinda?
Well, the last incident happened when I was supposed to go and collect the kids. I phoned her and told her that I'm on my way, and she said, no, I need to come a bit later because the kids need to attend a birthday party. But we always, you know, scheduled it about 2 weeks ago, so she never informed me before that. And I was not happy with it because I had to drive alone 2.5 hours to get there. And if I only leave at 6 o'clock, and it's a dangerous road, I'm only going to get late. So we were starting to have a bit of a quarrel about that. And Andre was sitting next to me, and he took the phone out of my hand. And then they became into a fight. And they were yelling at each other. And then Andre said that in more harsh words, that he had enough and she must take the kids because that is what she wants and he never wants to see them again.
From the beginning of 2009, what happened with the children?
Well, we never saw them again after that.
Now, how would you describe Marcel as a child during the period 2003 to 2008?
Marcel was a very beautiful kid, well-mannered. She loved to play school with her dolls. She loved to help me to prepare food. And she was very kind and loving. And yeah, she was also very lovable towards the animals and the dogs that we had.
Now, you've testified that this contact, or that he told her that he wants nothing to do with the children. Was there any other reason that you know of that this contact between father and children was halted?
Well, I spoke to her once and I asked her, well, I said to her, you know, Andre, he can be like that sometimes. Don't you think that we can just forget it? And she was very not nice with me. And she said to me, well, Andre made his decision. And she also explained to the kids that he made the decision that he doesn't want to see them ever again. And because she also told him that the manner that he, or the attitude that he had against her, and fighting all the way, always because of the money. And so they decided that they don't want to see us again.
So she told him that the children don't want to see him.
Yeah.
And he also said that he doesn't want to see the children.
Yes.
Did she tell, do you know that she told the children that he didn't want to see them?
Yes, she did.
Okay. When was the next time, or after 2009, which you said was the last time you saw the children, when was the next time you ever came into contact then with Marcel?
In December 2018.
Are you still married to Mr.
Sorry?
Mm.
2018.
Yes, last year, 2018.
Are you still married to Mr.
No.
When did you stop being married to?
We separated in 2013 and got divorced in 2014.
And during 2012 to 2014, was there any contact, or if you know of it, any contact between you and the children?
No, not that I was aware of.
never reached out to her father after 2009.
She really believed that he didn't want to see her ever again, and her mother also made her believe that.
And then what is the reason that you decided to see Marcel again in December 2018?
I just had an urge to make contact with her and her brother, and to see them again. I wanted to be there for them.
How many times did you see her?
About twice a week.
And what transpired between the two of you? And what did she tell you?
Oh, well, we spoke about a lot of things, but I think the things that stand out the most was that I convinced her and I asked her that whatever she do, she must please tell the truth to the court. It's important, and it is like, if you tell the truth, it will make you free. And I also, during our conversations when I saw her, I told her that if she ever needs to know, I called it the missing years. What really happened, why did her father not wanted to see her, she can ask me that.
And during these visits, what was her, or how was she feeling? Did she express anything to you about her feelings or what she was going through at that stage?
After she then once asked me to tell her what happened, and after I told her what really happened between her father, that he and Miranda was always fighting and arguing, and that he couldn't take it anymore. He said he felt like she was using the kids as a weapon, and that he felt like it was a sword that was hanging over him. She was very, I think, confused and sad and angry, because she told me that she didn't know how to react to her mother, because they were always very strict on not telling any lies at the church, and her mother lied to her. And she never knew, or she thought, she don't know how she's ever going to forgive her for that, because her mother made her believe that her father didn't want to see her. And she also she took away the opportunity for her to maybe live with her father, and then nothing of this would have ever happened to her. She also said that Miranda and Cecilia made a choose between them and her father that's not loving her and is clearly hating her. And they also blamed her for being disrespectful, vain, egocentric, and that she pushes God away with her attitude. And she also mentioned to me that she was even too scared to think, because they were fighting and with her even about something that she was thinking. She's not even done yet or said yet. She was also not allowed to have any friends and boyfriends during that time, because it will cause demons to approach Cecilia. And I think also she wasn't allowed to grow her hair like longer than this and wearing makeup, because that she was scared that, or well, I was scared that it will lead the demons to Cecilia.
And what did you do to install some hope in her, or if anything? What did you say to her or do to her to encourage her at that stage when you were visiting her?
Well, I encouraged her that I think that she should go ahead and tell the truth of what happened. And then she, I think it was towards the end of February 19, that she told me that she decided to tell the truth. But she was scared, because she already told the truth, some stuff in the court, and she didn't know how she's going to explain to the court that she told him that, and now she changed her mind and she's telling the truth.
And what was the reason that she wanted to tell you?
She said she wanted to tell the truth because she was done lying and sick of all the lies, and that there was some stuff that happened last year, and I wasn't here, so it was something about the testimonies of the other people, that made her doubt into Cecilia, and that she didn't believe her anymore. And she was just scared because she was supposed to go and stay with Cecilia and Andries when she get out of there. And if she now turn around and testifies against them, where will she end up? Where will she stay? So I told her, listen, you know, my place is always open for you.
It's 1:05. I still have a few questions for the witness. I don't know if the court would want me to.
How long will this be?
I have a few questions. I don't think it will take more than 10 minutes.
Could you maybe just do the 10 minutes and take it from there? Ms. Mel?
It's fine.
Mr. Kutsa?
Order with me.
Yes, let's proceed.
Now, after Marcel testified in the court, did you see or speak to Miranda again?
Yes, I did.
Where was that?
At the jail, I know it is in City. I don't actually know.
Okay. What was the purpose of that visit?
Well, I visit her sometimes. I think maybe I was trying, or I think I was trying to get the truth, to see if she can't maybe trust me enough to tell me the truth of how she got the children to do everything. Because I know that the children never did this out of their own. Knowing her and going through all the stuff that I went with together with her and Andre. And yeah, that is when I visited her.
And at that stage, it was after Marcel had testified.
Yes, that's correct.
What did she say to you about Marcel testifying, and what was her reaction to that?
She was very unhappy because she told me that Marcel, you know, if she just sticked with the story that she, Miranda, testified to, she would have had a chance to got released. And that she shot herself now in the foot because now she will never get out of there. And yeah, that was about what she.
And did she give you any messages for Marcel?
Yeah, while we were sitting, well, it's from the beginning, well, at the beginning, she said to me, whatever I do, I must please make sure that Marcel don't go back to that jail because they will take her out.
Now, what did you understand by that?
Well, I understand that they're going to kill her. And I do think because she scared me. She scared me with a lot of stuff that she told me. And, you know, I know she's capable of it. I'm even walked out of there and I thought I'm never going back there, but I'm not going to tell her that because I'm scared about her about her also because I don't know what she's capable of. Because once she told me about the scenario that was happened in the beginning of the year of that person who killed 40 people in New Zealand, and she said to me that he made her look like a child because he killed 40 people and she only killed 11 people. And it was like, you know, she liked the name serial killer because she really used it a lot.
Now, if ever, or if at any stage in the future, Marcel were to come out of prison, if she does go to prison, where do you think, or where will she go?
Well, as I told her, I've got place for her, and she's more than welcome to come and stay with us.
And what was her response to that?
That she will, and that she will really love to be part of our family. And I would really like to give her a chance to live life without fearing or without, you know, just to be free, to live her life.
Is there anything else that you wish to add to your evidence?
No.
Thank you, Maria. I have no further questions.
Mr. Kutsa?
No questions,
Sorry,
no?
Ms. Mel first.
Thank you.
Mr. Kutsa?
Nothing, no.
Roberts?
I have questions, my lord. Can we take the lunch agenda?
How long will you be?
Half an hour?
Bearing in mind, I think you said that your witness, your expert will only come tomorrow.
That is true, my lord. She is testifying in her last case.
Well, I think we've had a long day. Maybe we should just take the lunch adjournment now. Until what time?
2.
2 o'clock. We'll adjourn until 2 o'clock. You'll have to come back at 2 o'clock.